All right, everybody. Thanks for joining us. Welcome to the Creative Finance Collective. This is our opportunity every week to get together and talk about all things creative finance related. And so we're taking questions the entire hour. We're going to be here, rain or shine, loud or quiet, whatever the universe brings us, we will be here waiting for you, questions or none. But we're here to answer them. So if you have a question, related to creative finance, real estate law, go ahead and post it. We're happy to take it and hear what you have and work through it as best we can with us. So I'm Andy Fowler. If you're not familiar with me, I'm an attorney in Arizona. We have Sean St. Clair and Elizabeth Best, also attorneys in Arizona. We may have other members of the collective that'll join us throughout the hour. So stay tuned, see what that brings. But in the meantime, if you have questions, go ahead and give them to us. Sean and Libby, how you doing?
Good.
Doing well.
What's the latest?
Oh man, it's crazy out there. There's a lot of this market, and I think it's only going to get busier. To me, it's almost like if you're not doing creative financing, you're not able to operate in this market. And it's
yeah,
tough.
It's interesting you say that. So today was the monthly economic inflation, CPI numbers that they report, and inflation came in at 3.7% year over year. So just to give a perspective, 3.6% is what they were expecting. 3.2% was the year on year, was the previous month. So last month, the year over year was 3.2%. So we've gone up at 3.7. So it was higher than expected. Now, core inflation, depending on how they define core inflation, was at 4.3%, and 4.3% was expected. Previously, last month, it was at 4.7%. All that to say is inflation's still sticky, and it's not, even regular inflation was just slightly up than it was last month. Now, maybe that bounces around and it goes down even more, but it's not going away. And when people say, inflation's going down, the only thing that's going down is the rate of increase that it was increasing over what it was before. It's not like they give us back what we lost, right? It's like, no, the rate of increase is slowed from the 10% it was at one point, but we're still at a place where inflation is a real problem, and where inflation's a real problem, selling your home the conventional way is a real problem, right? I mean, that's the big issue. That's why we're here.
Right. Yeah, and with interest rates what they are, and the inflation numbers are always interesting. I'm a big fan of the dollar store, and so
Is it even the dollar store anymore?
well, no, and let me explain. It's now the $1.25 store. That's 25% inflation. Now, is a quarter going to break the bank? No. But at the end of the day, that is 25%. Like, you go into the dollar store, now, and, what used to be $1 is now $1.25. And, I don't know how that's not 3% inflation. That's not 10%. That's literally 25% inflation. Now, it's been like that for, I think, a good year now, but it's really interesting to, to see these numbers, but then also to go to your local store, your grocery store, your gas station, and, actually consume, and you realize, I'm not sure about 3%. To your point, Andy, that's just 3% over this certain period, but I think over the last however long, I think inflation's been significantly more than that. And then when you have high inflation and high interest rates, in theory, your housing prices should go down a bit because that's less that people can afford. But we're still seeing, not in all parts, but we're still seeing with housing, like, nobody wants to sell, so you still have really low inventory. Yeah, it's crazy,
Yeah.
But
yeah.
One of the things we were talking about before the show, and I kind of wanted to get into it here because it's probably a good place, and having Elizabeth on is helpful too, because her and I kind of got dragged into, a transaction. And one of the things we realized and I took away was the importance of certain provisions in your subject to contract. We resolved it. We got the issues resolved, and it was fine. But
these are provisions that people are missing when they run with the deal.
Right, that they're executing a contract, and then there's things in there that's like, I wish they either weren't in there, or B, I wish there were things that were in there that aren't. So one big thing is like performance deeds in lieu of foreclosure in advance. We've had a long discussion. We've had lots of discussions on the Creative Finance Collective with tons of other attorneys. And there's pretty much a consensus that that's just not a good thing. That a traditional wrap where you give the buyer, not the buyer, you give the seller, a promissory note and deed of trust.
Right.
To me, that's what you want to do, and not do a deed in lieu of foreclosure, not do a performance deed. So, if you're entering into a subject to transaction, don't put in the contract or an addendum or otherwise any language that you're going to do a performance deed. Instead, put in there that you're going to do a wrap transaction whereby you're going to deliver to the seller a note and either a deed of trust if you're in a deed of trust state, or a mortgage if you're in a mortgage state. So,
So were they misnaming the documents they were going to use in the transaction?
No, they just had in there that they were going to give the seller a deed in lieu of foreclosure or a performance deed, and there was an addendum stating that. And then, that had to be obviously dealt with and handled. But the preference is not to have that in there, not to do that at all. So that's first. The second thing that we've come across that needs to be addressed, and my most recent version of my Creative Finance purchase contract has this language in there, which is, if you're going to do a net to seller, then you need to make it very clear that that's that's net to seller, meaning that's all that the seller gets from the closing of the transaction. So you want to put in there provisions that say that the numbers, the purchase price, the cash at close, all the numbers adjust either upwards or downwards, so that the seller only walks with X amount of dollars. Mm-hmm. If that makes sense. So if the loan payoff comes back higher, then you need to bring more money to the table so that the seller walks. If the loan payoff comes in lower, then you need to adjust the purchase price and the cash at close of escrow so that the seller walks with just the net amount at closing. Because otherwise, that's what everyone intends. But if there's no language in there to the contrary, it creates potentially an ambiguity. The other thing is, if you're going to release earnest money, and I've seen this now a couple of times, if you're going to release earnest money before close of escrow, so you say, well, if title's clear, seller, you can take half of the earnest money. Maybe the seller needs to pay for moving expenses or something like that. So you're gonna release the money early, but the seller was supposed to have a net amount at closing. You need to put in the purchase contract that if we release this earnest money, it reduces your net amount at closing.
Mm-hmm. Yeah.
So, and there was one other, Elizabeth, do you remember what that was? One other thing that we came up against.
I was talking to Andy before you got on about the durable power of attorney and the witness. Like, we don't put stuff in for fun, it's a requirement. And if you don't properly execute it, we might have problems in the future.
Yeah, that's another issue, is making sure to, have that properly filled out and executed. Oh, the other thing is, on the subject to addendum, making sure that the seller appreciates the terms of the seller financing, the wrap financing. Most investor buyers don't want to, they don't want to do on sale clause in their wrap note and deed of trust. They want to be able to, potentially wrap the wrap or do some form of disposition with the property, maybe a long-term lease with an option to purchase, whatever. But if you have a due on sale clause in there, then you could have a seller that has seller's remorse and then finds out that the property's been conveyed, calls their loan and forecloses on the property, right? So you can't have a due on sale clause in there for an investor buyer who plans to, utilize the property as an investment and possibly sell it on a wrap or a subject to. So you need to make sure though that, the seller initials or acknowledges, yeah, I know that this isn't going to be in there, because, let's face it, that's a pretty common term that you're going to see in, deeds of trust. So you don't want the seller coming back and being like, oh, you pulled a fast one on me and took out the due on sale clause and I didn't know. Well, no, you knew, because you initialed right here, which said that the wrap financing, the note will not have a due on sale clause, and, not is, underlined. So that's also an important provision that is not getting into contracts that in my view need to be in there. And not only just in there, not buried in the language, but called out and initialed by the seller, so that, part of this transaction, in my view, and the critical nature of these disclosures is, on the back end, when law firms like ours end up with the nasty gram from the seller's attorney saying, oh, this is, look at this transaction and this is that, and maybe they don't fully understand it or appreciate it, and then you point out all the different spots where the seller is initialed, acknowledging that they understand it, where it explains it, breaks it down, talks to them about due on sale, loans remaining against the property, the whole thing. And you have all these initials, you have all these acknowledgments, you have, language here, language there, language, all over the place, where it just can't be missed. So it's not like, oh, you buried something in the fine print and now, you're pulling a fast one on us. I mean, you want to call this stuff out. And if the seller doesn't want to do it, they don't want to do it, and you move on. But it's better than being dragged into a lawsuit. And so you need to call this stuff out, make it, bring it to the seller's attention. And like Elizabeth said, if we have things in our documents to be executed in a certain way, they need to be executed in a certain way. That isn't just because, we thought it would be fun to add a witness to a power of an attorney.
Right. If you're just joining us, we're taking questions for the entire hour on creative finance related issues. If you have a question, make sure to post it. Sean, it makes me think disclosure and lots of documents is not a new thing. Anybody who's done a conventional transaction has sat at an escrow table and signed a book, documents the size of a book, and there's a ton of disclosures. Now, nobody ever reads them, but to think that
Right.
in a transaction like a subject to transaction, where you're taking the property subject to the existing loans, to think that you're not going to have the same kind, if not more, requirements of some sort of disclosure just kind of baffles me. So the issues that you ran into recently, clearly it sounds like the problems they were running into in the deal were just bad forms, bad agreements. Were these agreements they just didn't spend enough time vetting through or thinking through? What was the issue, you think?
Probably using, out of date forms that the forms were fine. It didn't have the most, up to date and recent provisions or whatnot. So, and for the most part, there was a bunch of disclosure. It was just, in my view, missing some terms. And that's the other thing. And Jeff can probably talk about this because I see he jumped on, but just because you have a form doesn't mean that you don't need to properly revise it or change it to reflect the nature of that particular transaction, because not all transactions are the same. And that's the problem, is you have people who are out there trying to be attorney, trying to, make a one size fits all document for every transaction, but not every transaction is unique. So you have to, pay some money, in my view, to hire the attorney on the front end and say, okay, here's all the moving parts in this transaction. Make sure that it states in the contract exactly what we're wanting to accomplish and how it's all going to play out at the end. Right, Jeff? I see you nodding your head there.
Oh, I agree. You can have standardized forms, but there is no cookie cutter process for buying houses. You can streamline it, you can systematize it, but every house is different, every seller is different, and you've got it, particularly when you're starting to do, particularly in the creative space, you've got to be able to customize it. And I like to start with a really solid baseline template and then customize it in. And just this week, I had to explain to a brand new client that the number I sent it, I gave him a substitution of collateral form. And I put some language in there regarding 75% LTV. And he thought that was set in stone. And I go, no, that's just a placeholder. You can negotiate that. Maybe you can get it to 82. Maybe they're going to push back and get it down to 67. But it's a number that you can start with and then go from there to customize it to that particular deal. And he was like, oh, okay, great. I got it. Now I'm going forward,
Right.
So, yeah.
Well, your legalese there actually raises a topic that I'm not aware that we've discussed on the collective, or frankly, even in any of our podcasts, because it's a pretty complicated thing, which is substitution of collateral. So for those that are listening, I'll put it in layman's terms, which is what substitution of collateral means is you go and you buy a house, you have a loan against the house, and you and the lender agree that if you find a property and you buy a property that has a certain loan to value ratio on it, so much equity in it, that you can take that property and substitute it for the deed of trust or the lien against the first property. So basically you free up the first property to sell it or do with it what you may, and you move the deed of trust or the mortgage from that property over to the new property, and secure it that way. Not a lot of investors do that. What are some ways that you've put into kind of your forms to make it so that the lender will play ball on that? Meaning, it's one thing to put it in there, but if the lender's like, yeah, I don't want to do that today. Like, how do you make it so that entice the lender to be willing to do it when the time comes?
So when we've done it in both residential and commercial transactions, because I've done it both ways, usually I'm always representing the buyer who's negotiating that in advance, and they're upfront in their conversations with the seller who's going to become the lender on the creative financing, the seller financing. They're upfront and they bring that issue up and they talk about it. And I'll give you the first time we ever did it. The church that I belong to, that I do some legal work for, we were buying some land, vacant land, 20 acres from a farmer, so that we could build a new church building on there. And we wanted to be able, and we were getting seller financing terms on the land, and we wanted to be able to move his lien off of those 20 acres and go put it against another piece of property owned by the church, so that when we brought in institutional financing for the construction, we didn't have to bring in bank money to pay the farmer off, because the farmer didn't want to get paid off. He wanted the income stream. So these are the things that we talked about. We talked about income streams. We talked about getting equal or better collateral. We talked about LTVs. We talked about first versus second. These are all things that you have to talk about. And now I'm touching on this other hot button issue, which is we're now into an environment, folks, where you have to talk to the other party. You have to actually communicate with them. And I know all our Gen Zs are like, ugh, I don't like making eye contact with anybody. Can't I do it by text? No, you can't. Okay. You have to build some rapport. You have to build some trust. So we did it that way. And when it came time, we went ahead, we went back to the farmer and said, hey, listen, the bank's getting ready to fund the loan. We want to move your lien off of the dirt, just vacant land that's getting ready to get all ripped up and drilled for casings and all sorts of foundational work. We're going to move your lien off of there. We're going to go put it against the free and clear parsonage that the church owns. And he's like, will my payments change? No. Which would the church rather lose? Would the church lose the building, the home where their pastor lives in? Absolutely not. We're going to keep those payments made. So it all worked out. But it all comes down to get in front of the conversation and have it with the seller and bring up the importance of, hey, you want a payment stream. You don't want to suddenly wake up one day and go, here's a gob of money. Oh, by the way, you're going to have to figure out how much you owe the IRS on it now. You know, so just have these conversations.
Yeah. What about, and now that we're on the topic of, interesting, unique provisions of financing terms, do you also ever negotiate or work with your clients to negotiate rights of first refusal on, selling or assignment of notes?
Yes. When I'm drafting a note, and this is, okay. So I always got to stop and remember, which hat am I wearing? Am I wearing the representing the investor buyer, or am I representing the civilian seller or somebody in between? Who am I representing as to how I'm negotiating this? If I'm representing the investor buyer and we're creating a seller finance note, seller carry note, whatever you want to call it, whatever jurisdiction you're in, I will like to put a right of first refusal in there, or the ability to match any other written offer that the holder of that note may receive for selling either a portion or all of that note. And what that does in reality, guys, is it's a huge deterrent. That seller, if they're holding a note, great, God bless them, we're making our payments on time. If they run into a situation where they listen to a J.G. Wentworth commercial and it's their money and they need it now, they go send that note over to somebody to evaluate it. They read the note and they go, I ain't working on this, because whatever discount I come up with to make this thing attractive, there's somebody else who's got the right to trump me by $1. And so what it turns out is we'll get a chance then to have a second conversation with that seller. Oh, you need some cash? The payments aren't coming in fast enough. Well, we can accelerate in exchange for, I'll just make up an example. I can give you another $10,000 now in exchange for the next 12 payments of $1,000 a month. And things like that. So we can create those kind of conversations. But once again, you're going to hear, it's going to sound like a broken record tonight, guys. It's all about having the conversation with the other party to where it's always mutually beneficial.
Right, and to your point, and in fact, before you jumped on, we were talking about, disclosures. And one of the things, once again, what hat you're wearing, right? So if I'm representing the seller, my deed of trust always has a due on sale clause. It's going to. But if I represent the investor buyer who's going to want to do a later disposition, maybe on a wrap or, contract for deed or something like that, I don't want a due on sale clause in that deed of trust. And so, in that case, I like up front as part of the contract to have a provision in there that says the wrap financing, the deed of trust will not have a due on sale clause, and have the seller just initial right there, so that when you get to the closing table, it's not like, well, you snuck one past me. Well, no, you knew you initial, this is what you agreed to. So when we
We
talk
talked
your
about
right
it. You signed off
right.
on it. I prepared
Yes.
the document based upon what we talked about, what you signed off on. It's not a surprise. Here we are.
Yeah, and so
Yeah.
I'm guessing when you're going to do a right of first refusal, there's an addendum or some language in your purchase contract that basically, or even a substitution of collateral that has some, not probably the full clause, but some, statement in there as to what's going to be there, and maybe, have the seller initial or call it out in bold or whatnot. Letters. Yeah.
So I include language regarding a right of first refusal, a substitution of collateral, and a subordination clause, all in my notes and in my mortgages, where we talk about there is the eventuality that the parties agree that if should they mutually agree in writing, then this can be done under the circumstances. And we just really outline the circumstances to where the seller or the note holder is going to be secured by collateral of equal or greater value at the same or better LTV, with no impediment on their cash flow and things like that. We kind of make sure I'm not looking to do rip somebody off, pull a fast one on somebody. No, I'm just trying to give people tools to use. And I'm going to spend the weekend, this coming weekend, I'm going to fly down to Tampa, Florida. I'm going to spend it with a bunch of my friends at a seminar being taught by my friend Bill Cook called What Box. And Bill talks about the big dang hammer. And we have seen investors for the last decade with a one-trick pony swinging the big all-cash, close-quick hammer. And folks, I got news for you. The market is shifting. You better have something other than the big dang hammer in your toolbox. You better have some other things to talk about. You better have, seller financing. You better have subto. You better have subordination, substitution of collateral, right of first refusal, options. You need to start getting these tools in your belt. This is all elements of creative financing.
Yeah, so a subordination clause would be basically if you have wrap financing, and assuming that it's not just a performance or mere note, but it's, the seller has some, level of financing above the underlying mortgage, that you want the ability to basically refinance or find a lender to pay off that first position loan, the existing loan that you took subject to. You want the ability to pay that off without paying off the seller. So the seller's loan stays in place as a second. So you put in their documents that, look, I have the ability as the borrower to go and refinance and pay off that first and replace it with a loan of, the same principal balance. And you agree that will not trigger a payoff of your loan. Your loan will remain in second position. And to make that new lender happy, you're going to execute an agreement, a subordination agreement that we're going to record, that's going to state that you understand that this new loan's coming on board and that you're taking a position junior to that new loan. So that would be a subordination clause. Just throwing it out there because, we all know on this call, know what it is, but I'm sure some of the people maybe watching are kind of like, what's subordination clause?
I'm glad you're explaining how to use it, what it works. I'm really glad you're doing that because I didn't do that. I just jumped right in and all legalese, mumbo jumbo. But the key thing here is you're leaving that seller. You say, take your example, which is a great example. You buy a property subto, the seller's got a tremendous amount of equity. They've agreed to take their equity in the form of payments over time. So they're in a second lien position. The institutional lender that you took subto, they're in first lien. The market's now shifted. The property's gone up in value. You've made value, whatever you've done to it, completed a renovation, and now you're going to refinance it. And you're going to get rid of that institutional lender. everybody should be cheering for that, because the seller who sold it to you sub two, now you're improving their financial position because that thing's going to go off their credit bureau, even though you've been making the payments. So they should be cheering for you. But the only way it's going to happen is if they agree to subordinate to that new lender coming in and wiping out the institutional people. The other element, the reason why the seller should be happy, the seller financer should be happy, is they continue to collect their payment stream and they don't get this huge tax shock. Because a lot of people do not understand that, how do I say this? They don't understand the tax implications to a seller when you're doing a creative finance deal. It's not always an installment sale. You've got to always look around the corner for the IRS, I mean the KGB, and that phantom income tax issue that can come at you. You got to be looking around for the corner for it. Because if you're not aware of it and you do a deal and you don't do it correctly, and all of a sudden your seller gets slammed with phantom income tax, you think that they're going to be happy with you? Nope. You think that they're going to complain? Yep. You think that they're going to screw up your deal? You better believe it.
Yeah.
So, Jeff, do you think the conditions, or we're nearly at the kind of conditions, or maybe approaching it, where you'd get a lot of sellers that would prefer just that they get the removal of their collateral eventually, so it fixes the credit report, their credit report, but they would rather continue receiving payments rather than the lump sum?
If it's a landlord who's exhausted with being a tenant and is looking around and going, I don't want to go through another COVID eviction moratorium. And folks, I got news for you. We may see another one of these things crammed down our throats. And I hate to say it, but we've got an administration in Washington, D.C. that just does not care about the rule of law. It's sad. It's scary. So
well,
they
if it's happened once, you at least have to plan for the possibility again, right?
Thank you.
You have to.
Yes, thank you. Yeah. So you've got a burned out landlord who doesn't want another eviction moratorium. They just want to collect payments. And now they get a chance to collect payments without having to deal with toilets, tenants, turnover, and all the trash. So great. Now, once they understand that and they get used to collecting those checks, they don't want to rock that boat. So let's not rock that boat for them. Let's improve their LTV. Let's improve their credit score by getting this thing paid off with the institution. Everybody's happy. And now let's just let them continue to, collect, coast and collect, and don't rock the boat. Because if we accelerate on them, because if they won't subordinate, if we accelerate on them, then they're going to get hit with, the IRS is going to love on them, going to come up and go, hey man, that's a lot of money. How much is it coming to us? Yeah.
If you're just joining us, we're taking questions for the entire hour. We've got about 30 minutes left. So if you've got creative finance questions, make sure to post them with us here. We've got Sean St. Clair, an Arizona attorney, Jeff Watson, an Ohio attorney, Elizabeth Best, another Arizona attorney, and myself. Don't ask me any questions. I'm just here to run the show. So, but we're here to take your questions. So make sure to post them. One thing I'll ask you guys, see what you think. Earlier we were talking about a lot of the problems we run into with creative finance transactions being that the documents aren't done well or fully vetted. And it reminded me of, when we do estate planning work, we tell folks where we've done the estate plan, you know what, you need to come back in realistically probably every 2 years to have these documents look at. Circumstances change, facts change. And it made me think about really the creative finance space, in that it's evolving quite a bit. Whether your state, if you were to say, forget creative finance for a moment, but the wholesale, we always pick on the wholesale laws. If you would have locked in and had a perfect wholesaling contract and assignment forms and all of that stuff 2 years ago in the state of Arizona, that would no longer be a perfect contract, right? So, with changing dynamics, with understanding the market better, with dealing with state law changes in a given marketplace, what do you guys think is actually, even if you do have a lawyer vet your local forms, how often do you think, given those facts and circumstances, somebody ought to come back and have them re-vetted, in other words, with their lawyer?
I'm going to suggest every 6 months, and I'm going to give you an example of that. Earlier this week, I had to tell a investor in the state of Texas, I said, listen, Texas has got a new law regarding wrap mortgages. I heard about it last week, a week ago today, from some of the other guests that were on the show. I haven't read it. You got to go find out what this is. Something's just changed. You need to know. And I think if you're serious about your craft as a real estate investor, you need to make sure that you've got semi-annual checkups with at least two significant professionals that matter in your business. Your accountant, if you're not seeing your accountant at least twice a year regarding tax planning and strategy, you're making a huge mistake. And if you're not going in and seeing your local attorney that's handling some of your business operations and your contracts and some of your closings, and you're not working with them to say, hey, what's new, what's different, what's coming, you're making a mistake. You need to do those two things, probably at least twice a year.
Yeah, and I agree with Jeff. I mean, the law is always transitioning. So we always hear from outside of Arizona. Right now, it seems to be, quiet on the Western front here, but outside of Arizona, we hear about, different regulations, and they're gonna move, and other states are gonna adopt them. And I mean, I will tell you that, like today, Jeff shared a few things, and I'm gonna probably wake up early tomorrow and brew a cup of coffee and make a few revisions to my, subject to docs.
But that's what we all do. But that's what we all do.
Yeah.
And I'm going to make this comment. And, when I was back in the dark ages, when I was in law school, okay, back in the dark ages, real estate law was very boring. It was very stable. Not much changed. Well, folks, I got news for you. In the last 15 years, we have seen more real estate case law come down the pike and more regulatory changes come down at us than I think we saw in the previous 150 years. And we have got to pay attention, because when the economy shifts and the political dynamics that we live in now, where we have such a reactionary political culture and regulatory culture, you've got to be paying attention.
Yeah. Again, if you're just joining us, we're taking questions throughout the hour. Guys, we have a couple questions. First one here, am I hearing this right, that you are putting this subordination clause into the original note?
I am putting terms in the original note that say upon mutual agreement, it will be subordinated. So yes, I am not putting all of the mechanics in there, but I'm opening the door saying, yes, it can be done. So that we can't have a seller come back and say, oh, we never talked about that. I never agreed to that. I'm going to be like, that note you're holding on to, it's got language in there. You accepted the note, therefore I presume you read it. So yeah, it's there.
Yeah. And that hopefully in that agreement, combined with like a cooperation clause, gets you to where you need to fill in the finer deal points. But
Yep.
I mean, as a general rule, Jeff's 100% right. If you don't have agreement in principle on some idea, whether it be assignment of the contract or subordination or some other thing in that original deal, you can't rely on their good graces later on down the road. Because
you're gonna have to negotiate your tuchus off to have a chance at it.
Yeah. We got another question. If we are purchasing nationwide, what's the best way to keep up with the changes in real estate laws?
You want the privilege of buying nationwide, you better pay attention to what's going on in different states. If you're not, I'm not sure why you're buying nationwide. I mean, if you want that privilege, then you got to have that responsibility. With great privilege comes great responsibility. So I would tell you that at a minimum, you should be closing transactions. If you're doing it nationwide, probably you're a wholesaler, you should be closing transactions at a title company where they have an attorney involved, and you can double check to make sure that there's nothing new preventing this closing.
Yeah.
That's a minimum.
And yeah, and that's exactly right. And I don't know if Ohio has them, but we're all aware of the foreclosure rescue statutes for creative or wrap or subject to financing transactions, where, you know, if a loan is in default and defaults more than 30 days late, so you don't have to have an actual sale that's taking place, but if it's just in default, then you have certain disclosure requirements, and they are very specific disclosure requirements. It's not simply, oh, you have a 3-day right of rescission. That's one, but you have to be very specific on the language that's in that right of rescission, and you have to be specific on the dates and times. You even have to get it like almost down to the minute as to when they can rescind. Colorado is a good example of that. I know that there's pretty stiff foreclosure rescue laws there, and I think maybe 12, 15 states.
About 20 have it. About 20 have a foreclosure rescue statute. I spent a lot of time learning those various statutes from 2008 through about 11. And I figured out which state copied from which state and so on. And Colorado, Washington, Oregon, and California were all pretty similar. And so I got to the point about a year ago when I started hearing some of these people talking about doing subto on people who are behind in default. And I go, whoa, time out. Have you bothered to read the foreclosure rescue statute in that state? Yeah. And guys, I got some of the blankest, what are you talking about stares I've ever seen in my life. And I'm like, dude, you better, there's this thing called Google. Why don't you take the name of your state, put it in there, and put in the words foreclosure rescue law afterwards, and hit search and see what comes up. And I'm to the point now where I will not do a subto transaction on someone who's in either default or foreclosure. I will do a different kind of transaction that gets me the same net result, but I will not do it because in some states, it's a criminal penalty. And I'm not interested in anybody getting orange off of that.
Just one more thought, Sean. I might know you might have something to add. One more thought on this question about nationwide. Yesterday on our podcast, we were talking about transaction coordinators and lawyers and who does what role in this stuff. And the topic of building a team came up, right? This idea of build your real estate team. Well, your team should include a lawyer in every state that you're doing business with. And I don't think people appreciate, I think they think this is harder than it actually is. But if you follow what Jeff and Sean just mentioned, which is basically a 6-month checkup. If they did your documents and vetted them, 6 months is not that long ago. And you have them on retainer and you've got a lawyer that's already opened up a file. Sometimes this is a phone call. Sometimes this is a half-hour phone call saying, Jeff, hey, good to talk with you. We haven't done this in a while. It's been 6 months, but hey, I'm doing more stuff in Ohio. I need to make sure we haven't seen any significant changes. Somebody who's in the space, like a Scott Horn in Texas or an Alan Seschker in Texas, or you name it, if they know that, they're going to know and are keeping up to date with those laws. And I think the point of what I'm trying to make is this isn't going to be a $2,500 research project, probably. Now, maybe the law is significantly changed and it's a contract overhaul. And thank God you went and talked with a lawyer before you got into a big mess. But I don't think this checkup process with a bunch of different lawyers in different states is near as difficult as people seem to think that it is. I think it's a lot easier.
Yep. And I'm perfectly fine with this concept of building a team. I'm just going to say one thing. Don't forget to feed him and pay him. Don't forget to feed him and pay him, Yeah.
We should rewind the show and just start with that. The most important legal tip you'll get all day. Don't stiff your lawyer.
So, and I'll share this story. It has nothing to do with real estate, but it plays off of what Jeff was saying there. In law school, we had a professor, really cool professor, but he would teach night classes, and then he would go with all of us out to the local pub And, he would sit there and share war stories and whatnot. And, one night he's like, let me tell you, I have the best piece of advice for you as an attorney that you will ever hear. And, all of us are like, what? And so we all lean in, and there's probably about, 10 of us, we're all leaning in. And he goes, get your damn money up front. That were his words of wisdom. And you know what? It's true.
It's true, but none of us listened at first.
Yeah.
We all learned the hard way. Yeah, we didn't listen.
Yep. So, I mean, I've gone so corny to tell some of my clients, I call it the jukebox principle. Until you put the money in and hit the button, there's no lights, there's no noise. Nothing happens. You've got to put the money in.
Yeah.
And I'm and this is just a sign of, God being good to me and blessing me. I'm to the point now where if the money isn't in my IOLTA account, I'm not opening the file. I'm not picking the file up and doing work on it. Yeah. The client's being told, hey, you've got to bring the money back up, whatever. Because I'm not working for free anymore.
My favorite now I feel like this is a PTSD therapy session, but my favorite story was I was talking with a doctor. Well, I was a retired doctor, and it wasn't going to require a lot. It was a litigation matter, and it was I asked for the retainer, and that's going to be too much. We can't afford any of that. We barely pay you monthly. And I'm like, well, I can't do that. That's unfortunate. No, please, can you help? And I was like, well, do you have a credit card? I mean, you're a retired doctor. You probably have a credit card. Well, no, my wife won't let me spend on the credit card. And I was like, your wife is okay with you running up a debt with me. You're okay treating me as the credit card at no interest and all this other stuff, but you can't run it up on the normal bank that is set up to actually provide financing. I'm like, you got a credit card either way, and I don't want to be it, but
Yep. You don't want to be the payday lender at 0%.
Yeah. So if you're just joining us, we are taking questions through the hour, so make sure to give us your questions, anything related to creative finance. We're happy to help. Jeff, you mentioned earlier how this market's changing and the importance of having your tool belt ready for this market, because the person with cash or the old school way of doing things isn't necessarily where we're at. I don't know if a lot of the listeners, certainly when we've had you on our show, we've talked about this, but you're kind of the go-to guy when it talks about tax-free IRA investments into creative type financing stuff, or just anything related to IRA investing and legal stuff with regards to that. Are you seeing any sort of increase in activity and IRAs doing subject to deals? What's that look like right now?
I'm not seeing IRAs going out and aggressively doing subject to deals. But what I am seeing that's really interesting is IRA account holders have got a lot of cash and they're licking their chops, waiting to jump. They're waiting to buy in. And so they've understood it, and they're getting ready to come in. And these are the perfect people to go to and say, I need a 60-day loan. I need a 1-year loan. This is what I can offer you, and structure something to where they come in and it's on a profit participation basis or whatever it is, where there's enough juice to make it worth the squeeze, and go after it. I think, I know this. The last time we were in the housing market was in the dumper, 2008 through 10. It was investors who could access IRA money were the first ones on the ground buying stuff for pennies on the dollar. And it's going to be the same thing again. The people who can create the relationships with the IRA investors, with the IRA account holders, maybe it's their own money, maybe it's somebody they know, whatever it is they've networked with, That's where it is. I just pulled off last week a creative refinance deal, and almost all of the money came from IRAs. And I'm seeing a lot of people doing stuff with IRA money, and that's where people have the liquidity to get stuff done right now.
Yeah. Now, why don't you explain, if it can be done briefly for those listening, the tax advantages ultimately
Okay.
for doing that? I know it's not something you just jump into. I know you've explained in the past, get your feet wet in creative finance first before you try
Yeah.
this, but
And that's exactly right. I mean, the first thing I would tell you is whenever you're thinking about doing a deal with the self-directed IRA, always do it with regular money first before you do it with an IRA. So you understand how it works, because the IRAs have got a lot more rules to them. But the rules, once you understand them, they're not that bad. But the beauty of using a self-directed retirement account is you can pick and choose what you want to invest in. You're not stuck in stocks, bonds, mutual funds, ETFs, and things like that. Instead, you can do private placements, you can do syndications, loans, buy real estate, whatever you want to do, hybrids and things like that. But the power of it is that the money remains in the IRA account. You don't take the money out of the account. The money remains inside the wrapper of the IRA, so it continues to be growing tax-free while you're doing the investment with that IRA money, provided you use a custodian that knows how to let you do that. Companies like Quest Trust, Horizon, Equity Trust, iPlan Group, Camaplan, Advanta, and a bunch more that I can't think of off the top of my head. And I'm a huge fan of Quest Trust, privileged to sit on their board of directors. And so we see people doing all sorts of unique and creative things because they're investing in what they understand, and they're using money in an IRA, a 401k, an HSA, and all of that profit is tax free. And so you're not running uphill and against the wind. You're actually got an unfair advantage against everybody else, because, you know, if I'm doing hard money lending with non-tax qualified money, and I'm making, 15% on the money, by the time the IRS gets done with me, I might actually only be making 10 or 11%. So if I'm doing tax-free, if I'm doing hard money lending out of my Roth IRA and I'm doing it at 12% and 3 points, I'm way ahead because I don't have to give the IRS any of that money. And therefore it compounds faster. I hope that was a quick enough explanation.
yeah,
I mean,
it
I can
is.
go on for hours about the stuff you can do with self-directed IRAs,
Yeah, and it is a powerful tool. Unfortunately, it's one of those tools where, if you're young and you're hearing this, like if you happen to be on YouTube and you're 18 and you're watching us right now, and you have a lot of years to start funding, because there's limitations on how much you can fund each year, right? And there's not limitations on what you can transfer from another, but the funding. And if you're starting to hear this, all that stuff that your grandfather talked about saving, and this would be the place to start saving, because one day in the not too distant future, you can take that lump sum and start getting creative with it, just like what
Yep.
Jeff was saying.
And I can tell you that once you get to, and you're folks, you're going to be shocked at this. Once you get to about $10,000 in a self-directed retirement account, you can start figuring out some pretty creative things to do to start making some good rates of return. And when I say a good rate of return, I'm talking double digit. The first digit's a crooked number. And a crooked number, I mean, it's a 2 or a 3 going on up. And there's no bank CD out there that's going to get you anywhere close to that. There's no I bond that's going to get you anywhere close to that. And you're not going to experience the roller coaster ride of the NASDAQ, the S&P, the Dow, or whatever else is out there. So yeah, there's a lot of advantages to that. And you need to, once you get about 10 grand, there's things you can start doing. I mean, I've done deals with as little as $300, but you got to be a little creative to pull those off. But 10 grand is great. And then there is so much free education out there on YouTube from some of these custodial companies on how to do these things. And you can literally just spend days binge watching all the free training out there from companies like Quest Trust and elsewhere on how to do deals, due diligence, syndications, oil and gas, private lending, fix and flip, all those things with an IRA.
Well, and what are the beauties with combining the IRA strategy with the sub two is when you talk about how much money you need to come into a deal. Well, when you're talking about sub two, you're using, the prior lending as the lending, right? So you just have to come in with the money on top.
Yeah. And so this is the one point I want to go back to, because I'm glad you brought this up. If you're going to use a self-directed retirement account, like an IRA, 401k, particularly an IRA, to do a sub two deal, I want you to use an account that you've opened in 2023 or later. 23, we're not into 24, so you can't open one in 24 yet. But I want you to use one in 2023 because of what they passed late last year, what Congress passed late last year. I can't remember the name of the bill, but it basically
the Secure Act?
The Secure Act, yes, Secure 2.0. Thank you.
Yeah, 2.0.
The Secure 2.0 Act basically said, I'm sorry, it didn't basically, it clarified that a prohibited transaction is limited to just that account. So if you're going to go do a sub two deal and you're not sure what you're doing, go get a brand new Roth IRA, whatever custodial company you want to use, Kingdom Trust, Horizon, Quest, whatever, Equity, Camel Plan, iPlan, all of them out there, and just get the money you need to do that deal in that account and then go do it. So if it blows up, you've only lost that money in that account. And that's the safest way to do it. Now, so if I strike out, I lost a few $1,000. But if I don't strike out and I hit a base hit, say I get a double, maybe I even turn that thing into a triple, I've got a pile of tax-free money now sitting there.
So if it blows up on an investment in an IRA account established under Secure Act 2.0, if that blows up and goes south, that doesn't impact or expose money in an IRA that was created in a separate one that was created prior to that.
Correct. So we have literally firewalled it off. And so take advantage of what they give me and I'm going to run with it, if you know what I mean. Yeah. I'm going to whatever little rule Congress gives me, I'm going to turn it to the best advantage I can and go with it.
Yeah, that makes sense, folks. That's gold information. You won't hear that anywhere else, but from Jeff Watson.
And I think we've talked about that on one of the podcasts before.
We did.
So I'm glad you reminded me of it. But yeah, those are some nuggets that are just out there, and just take advantage of it, because I'm looking at the clock. I'm really cognizant of this, and I know you guys let me come on late, and I appreciate it. But I want to really emphasize this. Folks, we're in a different market. You may have been in the buy and breathe world where you look like a genius because you bought, you breathed, you held it, and it went up in value, and now you think you're a brilliant real estate investor. You paid all cash, you had a line of credit, whatever it is, great, fine, whatever. That market's gone. It's shifting. This is the time where you have to understand that whenever you're going to do something in the creative finance realm, real estate investing is a thinking person's business. You have to spend time thinking, and you have to go hire brain power that you don't have. I'm not an accountant. I'm not a tax genius. That's why John hires one of my friends, okay? I'm not good at bookkeeping. That's why I have an assistant. I'm not good at other things. That's why I have those relationships. Get that brain power, because creative finance requires thinking. It's not about pumping out a bunch of offers and seeing what happens. It's not about dropping 5,000 pieces of direct mail or sending out 10,000 texts and paying all cash, because that market is shifted. Maybe you can still do it. Maybe you can't. I don't know. Don't pay in it. Don't play in it. But if you're going to do creative financing, you've got to learn how to think and strategize and structure.
Yep, 100%. Well, that we're at an hour. It was a good discussion. We went through a lot of stuff. Jeff and Sean and Libby, thanks so much for taking the time to be with us. And let's do it again.
Yeah, this is always fun.
Yeah, it is.
Right.
Learn stuff every week. All right, guys. We'll see you next time.
All right. Peace.